As I've said on many, many occasions, I worked for 32 years plus in national security in Canada and security intelligence for both Communications Security Establishment, or CSE, Canada Signals Intelligence, as well as CSIS, the Canadian Security Intelligence Service, which is both SIGINT and HUMINT on counterterrorism. And so I know that world really, really well. But in the course of my career, I had an awful lot to do with law enforcement officers across Canada and around the world. Some security services, like the Scandinavians, combine law enforcement and security intelligence. Here in Canada, we have a very distinct role between the RCMP, the Royal Canadian Mounted Police, and CSIS, and that's for historical and judicial reasons. But I also did work for the anti-terrorism section of the OPP for a little bit when I retired from CSIS, and that's where I met my next guest. So I'm very pleased to bring to the podcast today Gavin Horner, who spent 32 and a half years with Toronto Police, and he worked on files such as homicide, guns and gangs, organized crime, and provincial anti-terrorism, as I mentioned at the end, and also in intelligence operations, which I find really quite fascinating. So Gavin and I are going to have this conversation about intelligence and evidence. So Gavin, thanks for joining me on the podcast.
Thank you so much for having me, Phil.
Let's start with basic principles, Gavin. What we often talk about the evidentiary standard here in Canada. What does that really mean? For you spent 32 years and a half with Toronto Police. What is the evidentiary standard from a law enforcement perspective?
Well, by my definition, an evidentiary standard would be a piece of information that is collected by law enforcement that would be admissible in a court of law. So, for example, at a stabbing, the knife would be a piece of evidence that once properly seized and once the continuity of that has been established, that knife as an exhibit at court would be admissible evidence. Sometimes police or security intelligence folks collect information that wouldn't be admissible evidence. And so we call that a bit of information, or we include that in a collection plan. And then after the information is analyzed, the product that we produce, an intelligence product, an intelligence report, or an information sharing report between agencies, and we sometimes put a classification level on that because some of the information, whether it came from a confidential source, whether it came from sensitive information that can't be shared, it would expose a confidential informant, that kind of thing would be considered intelligence. That product would be intelligence, not evidence.
Now, how does that complicate your life as a law enforcement officer when you're dealing with things that you say are collected in a way that makes them admissible to court? And you've got this other information, which, in some cases may have been shared by my old crew at CSIS or, the anti-terrorism section, which we'll talk about in a bit. Did that make your life more difficult? I mean, you spent time at Intel Ops in Toronto. How is that differentiation managed? Because I'm guessing that if you don't manage it well and you end up using information in court that's not evidentiary, the case could go south real fast.
Yes, it could. So you have to be very careful with, we call it sensitive information for a reason because it's sensitive and you need to treat it as sensitive information. So it's very important when two officers from different agencies are speaking that they're very clear about what the nature of the information that's being shared is and how it can be shared or if it can be shared at all. The standards by which CSIS collects information, as you well know, is a much different standard than law enforcement. The CSIS intent is never to take a case to court.
Right.
It's to provide advice to government to make decisions about different things, about national security and safety of all Canadians. But a court case is never their end goal. Whereas for law enforcement, if our investigations go well, traditionally, we end up with a court case at the end of it. And so we would like to make sure that whatever we do collect, and there's where I make a big distinction between, people often ask about the differences between evidence and intelligence, but I will often throw the word information into that mix to make sure that we understand that we're not talking about a piece of intelligence. The intelligence comes after it's been analyzed by super smart people like yourself.
Gee, thanks, Gavin.
That product is intelligence product, whereas the piece of information, it really is just a piece of information that could be evaluated on its own for whether it will meet the evidentiary standard. It might be one piece of a 10-piece puzzle that creates an intelligence product, but the information that's being discussed needs to be established as whether it's safe or sensitive.
You're absolutely right. In my time at CSIS, I know that we were very careful in how we shared information, especially with the RCMP, and I think to a lesser extent with local law enforcement like Toronto, for the reasons you cited. CSIS does not want to appear in court. And the difference between a CSIS human source and what you guys would traditionally call a human agent is that your agents can be asked to testify and often are the most important witnesses in a criminal trial. Whereas CSIS sources, one thing we tell them is that your name will never be divulged and you will never have to testify in court. So, picking up on that question, Gavin, can you walk us through, in your time in Toronto Police on the various files you worked on, just how important were human agents in getting, going to trial and getting guilty verdicts or guilty decisions on some pretty serious and nasty characters?
Yeah. So agents are a totally different ball game than, say, as we call the police would call an informant. An informant, we would do our absolute best and take every precaution necessary to make sure that that person's name and identity is never revealed, to the point where we have a pretty rigorous process by which we take out any information that could even reduce the pool of who the informant could be. So a police investigation commences based on confidential informant information. And for example, if a subject of an investigation was known to carry drugs in his car or house drugs in his car, but the only two people know that, and then we have a confidential informant that says that the subject has drugs in his car. Well, that person's identity, we could take his name out of the file, but his identity is going to be revealed because only two people knew that piece of
Right,
information.
of course.
So there is a rigorous process by which we vet any sort of information to eliminate the possibility that the identity of the informant would become known. And now an agent is quite different. When an informant is giving information, that person decides that he or she doesn't mind testifying in court, then that person becomes an agent. That word's not used by mistake. They become an agent of the police, and we can certainly use the information that they're providing to the investigation without the need for trying to keep the person's identity out, because when the court case comes up, that person is going to testify.
Right. And getting back to this distinction, Gavin, between informants and agents, just so I'm clear on the concept, can a law enforcement direct both, or are informant? Because we used to have people that would come to us with information, and that's thanks very much, but we didn't actually direct them to go and do anything. Whereas a full-fledged human source, once they're vetted, can be told, okay, we want you to go, become best friends with Gavin and find out X, Y, or Z about him. Is that same distinction made in law enforcement?
Yes, between an informant and an agent. An informant, the first thing we would tell them is that we appreciate you providing this information, but we need you to be eyes and ears only, and whatever you provide to us through the normal course of your day would be helpful. But under no circumstances would a police officer direct that informant to a certain specific area, because that would cause them to make the leap into an agent status. However, the only person who can waive their informant privileges, because the courts see this informant system as quite valuable, and they have rigorous rules about what you can and can't do, and the only person who can waive that privilege that the informant has is the informant himself. So
Okay.
if you do things that go outside the rules of an informant and turn that person into an agent, but they haven't waived their status, now you have a not prosecutable case. You've made a big mess.
Oh wow. No. Okay. Well, that's interesting. Now, there's a case going on now, Gavin, in Ottawa. I'm not sure what's happened since COVID launched, but there's a guy you may or may not have come across. His name is Auso Peshtari. He was picked up originally way back in 2010 in conjunction with Operation Samosa, which was a plot to bomb the Trenton Air Force Base. He was let go, not charged, and then 4 years later he was picked up And he had changed basically from a guy who was facilitating an act of terrorism in Canada, at least at the initial stages, to one who was recruiting people for ISIS to go abroad. Now he's become sort of the brains behind the outfit. And in this court case, the defense has been quite smart, and they've taken a police source, a police agent. That agent used to be a CSIS source and agreed to become an agent. And now we saw it for the Toronto 18 with Mubin Sheikh. I'm sure you're familiar with. He was originally a CSIS source, became an RCMP agent. He was one of the main witnesses in the testimony. The defense now wants to know what CSIS did with their source before he became an agent. And my contention has been, well, that's irrelevant. The RCMP, and this is the way, the CSIS RCMP relationship is that CSIS can give basically what's called a nudge, nudge, wink, wink to the RCMP. Gavin Horner is a bad man. And then the RCMP must take the information and launch their own independent, not parallel, not joint investigation from stage one. Do you see this as problematic if courts now say that in cases like this, where human sources become police agents, that the defense is allowed to have access to all of their files, including their CSIS files? Where can this end up down the road in terms of the viability of court cases?
Well, I'm aware of the fact that each case gets ruled upon by its own merits, and so there might be little nuances in that case where we didn't make that clean break. And I don't know the specifics of the case that you just cited in Ottawa, but where you leave defense counsel with an avenue to argue that case and to get access to things, the phrase that they use would be in order to make full answer in defense to the charge that their client
Right.
is facing. And so, if the RCMP or the local police, municipal police force that receives the sensitive information, where it's just a one sentence tip that says subject A is known to do bad things, and if you take that from there and any information that you collect is your own collection, then you have made a clean break. Where you start to receive a little bit more information from the originating agency or the originating member, then you start to blend those two files and you leave an avenue for defense to make an argument that they don't have the entire file.
Right.
So I'm hoping that the courts would rule that the scenario you just described does not happen, but I think that everybody involved needs to be very careful with the transfer of information and what gets moved over. When an agent moves from one agency to the other, I don't believe that their entire history should then be available. So, for example, if I wanted to become a confidential informant, I don't mind reporting on somebody that I work with, but I don't want to report on my neighbors, or I don't want it to be known that I was reporting on my neighbors.
Right.
If I become an agent for the file for which my work colleagues are charged, that shouldn't mean that everything that I've ever given the police regarding my neighbors is also open to public view.
Right.
So I'm hoping that the courts would rule in a way that makes it so that there is a clean break, and that the entirety of that agent's history with the state, so law enforcement and CSIS, shouldn't be known to the public.
Right.
But both agencies need to be careful that there needs to be a very clean break. The one sentence, here you go, and you take it from here, should be adhered to strictly.
I couldn't agree with you more, and this is why I think the RCMP and CSIS have come up with a mechanism to do that, and it's adhered to as close as possible for the reasons you cited. I guess we all acknowledge that lawyers have a right to defend their client, and they can only defend their client if they have all the all the information available at any given time. So it's kind of it's a tricky kind of game to play, I suppose. Now, in your time working for Toronto Police, you did work in intel ops. There's a lot of us you can't tell us, but how does that work within a law enforcement agency then? And you have an actual intel division. How does that jive with what law enforcement normally does?
Well, the intelligence unit the section of intelligence that I worked at was the operations section, which would focus on organized crime. And what we would do is we would look for different people or groups of people that were known to be up to no good. And we would collect as much information as we can about those
Gavin, are you
people
there?
and those groups, and we would make associations to group members, and then we would create a collection plan, and then we would maybe conduct some surveillance. Maybe we would try and develop some more confidential informants, and then our analysts would take all the information that we received. Here I go back to my definitions lecture, but we would receive or take all the information that's known, create a collection plan to add more information to the bucket, and then analyze it for why it's meaningful, how significant and how dangerous or how effective is this group at engaging in criminality. Once we've made a perhaps not a clear enough picture for a courthouse or for a judge or a jury, but we've made a clear enough picture that an enforcement team could take the information and the intelligence product that we've started, and then they could move that forward with an enforcement initiative. They could collect information on their own. Some of the information that we use to create our intelligence product could be admissible. Some of it could compromise another file. Some of it could compromise the identity of an informant. But in some cases, the information that we collected could certainly be used as evidence at a later trial. But then that enforcement team would conduct their own investigation and then do what they can to put together a case that would make for a successful conclusion or a successful convictions at a courthouse.
Last question for you, Gavin. As I said, when I met you, you were seconded to the anti-terrorism section of the Ontario Provincial Police, which I joined in May of 2015. I don't want you to, provide any stories out of turn kind of thing, but can you describe sort of your experience with OPP PATS, how that was similar to or different than what you were doing with Toronto Police, and whether or not when you were with Toronto Police, you had much experience with terrorism files as opposed to the other files which you worked, as you said, you worked with a lot of different files while you were with them. How did that experience with the provincial police force that had an anti-terrorism section, how did that change life for you?
Well, you're quite right that there are some similarities, but the in the way that we collect information, analyze it, and then share it with somebody else for an enforcement initiative or for whatever initiative that other agency might find the information useful or the intelligence useful. So in that regard, it was a very similar process. Um, we were designed as an intelligence branch, so information would come to light that didn't make for a significant enough case for the enforcement team, the Integrated National Security Enforcement Team,
Right. The
overseen by the
incest. Yeah.
RCMP. That wouldn't be significant enough for them, so they would leave it with us, and we would develop a collection plan. We would collect more information on the subject or subjects, and then our analysts would try and make a clearer picture of what the information means, and why it's significant. And as we progress through our intelligence probes, uh, we would meet regularly with INSET and discuss at what point, if at all, it's appropriate to turn that file over to them to take an enforcement initiative and then do something more significantly designed to disrupt their activities or make an arrest or an 810 peace bond or whatever steps they deem appropriate. So the process by which information is collected and then analyzed and then distributed is very similar. Just the content was different. It wasn't organized crime members doing things for their own material benefit. It was now a terrorist group or members of a group that are engaged in terrorist activity or might be engaged in terrorist activity. It's just the content of the information that's being analyzed and shared is different, but the process is quite similar.
Now, of course, OPP PATS was it only was created after 9/11. I believe it was in 2002, and it was created. In all your time, excuse me, in Toronto Police, Gavin, how often would you come across files that either developed into terrorism files or eventually, you could tell from the get-go that there was some kind of an overlap between what would be, if I can use the term, run-of-the-mill criminal behavior and terrorism behavior, reminding my listeners that, terrorism was only added to the Canadian Criminal Code in the wake of 9/11. There was no terrorism clause in the criminal code prior to that. From a law enforcement perspective, was this something that was really new, or was it more or less something that you could develop quite naturally given the kind of mandate you had in the days prior to 9/11?
I had very limited exposure to anything along these lines until I went to the provincial anti-terrorism section. So perhaps it was just based on where I was assigned and the kinds of files that I was assigned to back in those days. But I don't remember a time at all when an investigation that we were conducting merged over into a file that needed national security investigators to either take it over or take a piece of the investigation for their own purposes. It's quite often the case that um, uh, maybe not as prevalent in terrorism cases, but sometimes it's not as simple to say is this terrorism or is this organized crime. Sometimes it might be a little bit of both, and so both agencies are keen to see it through to a conclusion. But prior to my time at provincial anti-terrorism, I didn't have any exposure to cases that then needed to be um, sent off to INSET.
What about, I've often thought that maybe we don't need to call terrorism terrorism because terrorists are engaged in activities that are already crimes: murder, conspiracy to commit murder, attempted murder, etc. Do you think that our world would, and that our law enforcement and our national security agencies would somehow be better off if we didn't give terrorists the credit that they're seeking? We're terrorists, we're really big, we're really important, and just call them run-of-the-mill murderers, given that the crimes that they're planning and are committing have been crimes that have been investigated by law enforcement since the beginning of time.
Yeah, that's you make a good point, and it's certainly worth conversation. I think that you and I on a Thursday morning probably can't solve that one, but there is something to be said for that. The section is designed to identify what terrorist activity is, and terrorist activity, as you know, is defined where the motivation is political, religious, or ideological in
Right,
nature.
right.
And so we would call that we would call that the information that puts it over into a terrorist realm, but the offense itself is still an offense. Why don't we just charge them with? And you said murder. Well, murder is pretty significant and carries a stiff penalty. But what if the offense is only mischief, or
Mm.
only theft, or only something quite small that the courts may not give that subject a stiff enough penalty to deter future terrorist activity. So the fact that there is a specific section which identifies terrorist activity and then not just defines terrorist activity, but then lists the offenses. And you and I've had a conversation before about the different terrorist offenses that are there, save and except the actual definition of terrorist activity. Um, but I think it's significant and meaningful in that somebody who does something for that purpose could be in that given that special attention by the courts that a thief or somebody who's committing mischief may not get.
That's a good point. I hadn't thought of that because obviously, not all terrorists are committing murder. Some are financing, some are facilitating, some are just hangers on. That I use the phrase here. I used to hear a lot about when we used to interview people that were in Afghanistan, and the line there was, "Oh, I only drove the bus." Right? No one
Right.
ever did anything nasty. They all drove the bus, and as a way to kind of uh, move attention away from what they actually did in Afghanistan. Gavin, I think you provided us a really interesting insight into the whole law enforcement, security, intelligence world and how the roles both differ and how they merge. So, is there anything else you want to add about sort of what it's like to work in that field and have access to national security files that are very sensitive in nature?
Well, just the transition for me was quick. I moved over into that section as a staff sergeant in charge of the section, and it was a joint forces with multiple municipal agencies. And so, when information sharing is significant, and I think that was what was identified after 9/11, in that a whole bunch of different agencies may or may not have information that if shared in a bigger bucket, we might be able to make sense of some of it. So that piece of information by itself isn't all that significant or meaningful, but then the neighboring police agency has some information, unless they know to share it. Then how do they know to compare it to each other? And then both pieces of information become more significant. And so rather than having one agency do cold calls to different intelligence sections to say, what do you have on this subject? Having people seconded from those agencies made the attempt to get information from those agencies, where you have someone on loan and seconded to it, much smoother. And so most larger agencies, I mean, some police agencies are quite small and don't have much of an intelligence section, save and except one investigator who does drugs, guns, murders, and intel. Certainly wouldn't be in a position to second someone into the terrorism section, but most of the larger agencies do. And I think you'd find that most of the larger agencies see value in it, and great success has come from having a seamless sharing of information because they have a member in the section, and conversely, we can access information from that agency by just asking the seconded member to go and get it for us, as opposed to making a cold call.
That's a really good point, and you're right. I think secondments have proven to be a very valuable tool for both law enforcement and security intelligence. Of course, CSIS has people seconded to the RCMP. We've had people seconded to the service, and as you mentioned, OPP Pats had people seconded. I mean, you were seconded. A lot of other people were seconded. That's a really good point. That the more you have people from a variety of agencies weighing in on these things, and they know their own agencies well. They know whom to contact if things need to be divulged, and it just makes the process earlier. And as you said, in the wake of 9/11, there were a lot of allegations, probably true to a certain extent, that information that was there but was not shared because people just didn't know how to do it, or didn't have the rules, or weren't quite sure on how to get this thing done. And as a consequence, maybe some of the actors could have been identified beforehand. Gavin, this has been really interesting, and I really appreciate you taking the time as somebody who served, for more than 3 decades in law enforcement. It's a world that I only had I dipped my toe in at the very, very end after I retired from CSIS. And I think your insight into the working relationship between law enforcement and security intelligence, the role that law enforcement plays in the national security realm, and the whole distinction between intelligence and evidence has been really, really useful for me and my listeners. So thanks for taking the time.
I'm happy to have participated, Phil. Thank you so much for having me.
So that was my conversation with Gavin Horner, a veteran Toronto police officer. What do you think about evidence versus intelligence? Should it be a more seamless sharing of information? I'd like to hear from you. You can reach me on email, borealisrisk@gmail.com, or on Twitter @BorealisSaves. You can also find me on LinkedIn and on Facebook. If you like the content and want to get more, go to my website, borealisthreatrisk.com, hit the subscribe button. You'll also find a link there to my latest group, The Peaceable Kingdom, History of Terrorism in Canada, Confederation of the Present. Love to hear from you. We'll talk to you again soon. Take care.